Daf Yomi, Daf Yomi, Daf Yomi, Daf Yomi. Tractate Shevuot 31a. Top of the page with the words Kolar, Talui, B'tzavar Edim, Talmud Lomar, Midvar Sheker Tircha. The chain, the kolar of culpability for the miscarriage of justice be placed around the neck of the false witnesses. It is derived, as the verse states, distance yourself from a false matter. Siman, tilat tamid, utilat balechov, samartut, shomea umatiim. The Gemara provides a mnemonic for additional halachot derived from the verse, distance yourself from a false matter. 3 relating to a student, and 3 relating to creditors, and 3 relating to a judge. Rags, hears, and explain. Okay, let's go through it again. Rags, like shmatas, rags. Hears, meaning listens to, and explain. Minayin letalmid shioshev bnei rabo v'ro zechut le'ani b'chov le'ashir. Minayin shelo yishtok talmud lomar midvar sheker tilcha. From where is it derived with regard to a student who is sitting before his teacher and sees a claim that provides advantage for a poor person and a disadvantage for a wealthy person, that he should not remain silent? Now, I must say that I'm curious about the gematria of Midvar Sheker Tirchak. So let's find it out right now. Midvar Sheker Tirchak, never tell a lie. Hashem knows just what happened, there's no reason to deny. 1554. Okay. Al-Bam, 275. At-Bash, 490. Alright. No immediate connections. Other than 490 is 49th of the Omer today. From where is it derived with regard to a student? Yeah, okay, right. Minayin Talmud says, "Ram Shitoybedin Shlo Yoma Amtin Lo Ad Shigmerenu Vastirenu Vavneu Misheli Kedei Shikore Hadin Al Shemi Talmud Lomar Midvar Sheker Tilcha." From where is it derived with regard to a student who sees his teacher who is erring in judgment, that he shall not say, "I will wait for my teacher until he concludes the trial, and then I will contradict him and construct a ruling on my own, so that the verdict will be attributed to my name"? It is derived, as the verse states, distance yourself from a false matter. Minayin letalmid she'omar lo rabo yodea ata bi shim notnin li me'amane eno mevadeh מנה יש לי אצל פלוני ואין עליו אלא עד אחד מניין שלא יצטרף עמו תלמוד לומר מדבר שקר טרחה. From where is it derived with regard to a student whose teacher said to him, "You know concerning me that even if one were to give me 100 times 100 dinars, I would not fabricate a claim. Now, I have 100 dinars in the possession of so-and-so, to whom I lent money, but I have only one witness of the 2 required to testify about the loan and enable me to collect payment." From where is it derived that the student shall not join with the other witness and testify? It is derived, as the verse states, distance yourself from a false matter. Exodus 23 verse 7. Hi, midvar sheker tirchak nafka, havadai shekore kamashake. Berachmana amar, lo tana beracha et shaker, ela kegon dehamale, vadai Chad Sahada Itli. V'ta'atakum. Hatam lo temav lo midi. Te'alama kebipumach shekra. Afilu achi asur mishum shneemar midvar sheker tirchak. Okay, the Gemara asks, is it from the verse, distance yourself from a false matter, that this matter is derived? But isn't he certainly lying in that case? And this is already stated, as the merciful one states, you shall not bear false witness against your neighbor, Exodus 20:13, rather. The reference is to a case where the teacher said to him, it is certain that I have one witness, and you come and stand there beside him and do not say anything, as in that matter you do not express a lie from your mouth. Your silent presence will create the impression that I have two witnesses and lead the debtor to admit his debt. Even so, it is prohibited to do this due to that which is stated, distance yourself from a false matter. מנין הנוסבך ויאמנה שלא יאמר עתנו במאתיים כדי שיודה לי במנה יתחייב לי שבוע להתגלגל אל השבוע ממקום אחר תלמוד לומר מדבר שקר תרחק. There are three halachot with regard to a creditor, from where it is derived, from where is it derived with regard to one who is seeking repayment from another of a debt of 100 dinars, and there are no witnesses to that effect, that he shall not say, I will claim that he owes me 200 dinars, so that he will admit that he owes me 100 dinars, and he will become liable to take an oath to me. The oath of one who admits to part of a claim, and on that basis I will extend the oath and compel him to take an oath with regard to a debt that he owes me from another place. It is derived, as the verse states, distance yourself from a false matter. מנין לנוס וחברו מנהו טענו 200 שלא יאמר אכברנו בבית דין ועודה לו חוץ לבית דין כדי שלא יתחייב לו שבוע ולא אגלגל עליי. שבוע במקום אחר? תלמוד לומר מדבר שקר תרחק. From where is it derived with regard to one who is seeking repayment from another of a debt, 100 dinars, and claims the debtor owes him 200 dinars, that the debtor shall not say, I will completely deny his claim in court, and I will admit to him outside the court, so that I will not become liable to take an oath to him, and he will not extend the oath and compel me to take an oath with regard to a debt that I owe him from another place. It is derived, as the verse states, distance yourself from a false matter. מנין לשלושה שנוסעים מנו אחד שלא יהיה אחד בעל דין ושניים עדים כדי שיוציאו מנו אחד לא יקו תמו לא מדבר שקר תרחק. From where is it derived with regard to 3 who are seeking repayment from one individual for a total of 100 dinars, that one of the 3 should not assume the role of a sole litigant and claim 100 dinars, and the other 2 will assume the role of witnesses, so that they will exact repayment of 100 dinars from the debtor and divide it among them. It is derived, as the verse states, distance yourself from a false matter. מנין לשניים שבאו לדין איך הלבוש למטוטין איך הלבוש הצטלית בת מהמנה שאומרים לו לבוש כמותו או הלבישו כמותך תלמוד לומר מדבר שקר תרחק. כי יבוא עתו לקמת רבה באפונה אמר להו שלופה פוזמו קייכו וחוטו לדינה There are 3 halachot with regard to a judge. From where is it derived with regard to 2 individuals who came to judgment, one dressed in rags and one dressed in a garment worth 100 times 100 dinars, that the judges say to the wealthy person, dress like the poor person, or dress like the poor person in a garment like yours. It is derived, as the verse states, distance yourself from a false matter. The Gemara relates, when individuals would come before Rava bar of Huna for judgment, he would say to them, remove your fine shoes and descend for judgment, so that you will not appear more distinguished than the other litigant. Minayin nadayin shelo yishma divrei ba'al din kodem sheyevo ba'al din chabeot ama lo yado shevetincha. From where is it derived that a judge should not hear the statement of one litigant before the other litigant comes to court? It is derived, as the verse states, distance yourself from false matter. Minayin ba'al din shelo yatim dvarav l'dayin kodem sheyevo ba'al din chabeot. Talmud lo man midar shevetincha karav kahana mati. Matnemi lo tisa lo tasi. From where is it derived that a litigant shall not explain the rationale behind his statements to the judge before the other litigant comes to court? It is derived, as the verse states, distance yourself from a false matter. Rav Kahana teaches that this halakha is derived from that which is written, you shall not accept a false report. Exodus 23 verse 1, which he interprets as though it is written, you shall not cause others to accept a false report. The verse states, and that which is not good among his people, Ezekiel 18:18. Rav says this is referring to one who comes to court with authorization to present claims on behalf of another. Shmuel says this is referring to one who purchases a field concerning which there are those who contest ownership of it, as in that way he involves himself in the dispute of others. The Mishnah teaches that the oath of testimony is practiced only with regard to those fit to testify. The Gemara asks, this statement serves to exclude what person is not allowed to testify, who is not mentioned explicitly in the Mishnah. Rav Papa said it serves to exclude a king who, although he is neither a relative nor otherwise disqualified from testifying, does not testify in court. And Rav Acha Bar Yaakov said it serves to exclude one who plays with dice, who is disqualified by a witness to rabbinic law. Man di amal. Der Mesach Lukuya kol shchei melech. Man di amar melech aval Mesach Lukuya. Midoraisa michazah chazu rabbanan hu tif asalat asaluhu. The Gemara notes, according to the one who says that the Mishnah excludes one who plays with dice from the oath of testimony, all the more so should a king be excluded, as he does not testify by Torah law. And according to the one who says that the Mishnah excludes a king from the oath of testimony, it may exclude only a king, but perhaps one who plays with dice is not excluded, as by Torah law he is fit to testify, and it is the sages who disqualified him. Therefore, he is not excluded from the oath of testimony, which is by Torah law. Ifnei Bezdin, Yishalo Ifnei Bezdin, Kuli Makamiflagi. The Mishnah teaches the oath of testimony is practiced both in the presence of the court and not in the presence of the court, when the potential witness takes the oath on his own. And if the oath is administered by others, he is liable only when he denies in court any knowledge of the incident in question. This is the statement of Rabbi Meir. And the rabbis say, when the witness takes the oath on his own, or whether the oath is administered by others, he is liable only when he denies in court any knowledge of the incident in question. The Gemara asks, with regard to what do they disagree? The sages said, the explanation for Rav Papa, they disagree with regard to the method of derivation by means of verbal analogy, of a verbal analogy. It is a method to infer the halacha from the source of the verbal analogy and derive the details from that source as well. Or it's the method to infer the halacha from it, but interpret the halacha according to its own place. Rav Meir Savar, dun mine umine mipikadon, ma pikadon mushba mipiat mochayav, af edus mushba mipiat mochayav, umina ma pikadon, ben bevet din, uben shelo bevet din af edut, ben bevet din, uben shelo bevet din. The Gemara elaborates. Rav Meir holds, infer from it and derive the details from it. The halacha of the oath of testimony is derived from the halacha of an oath on a deposit, just as in the case of the oath on a deposit, one who takes the oath on his own is liable. So too in the case of the oath of the testimony, one who takes the oath on his own is liable, and derive the details from it, just as in the case of the oath on a deposit, one is liable whether he took the oath in court or he took the oath not in court. So too, in the case of the oath of testimony, one is liable whether he took the oath in court or he took the oath not in court. Rabbanan Savri, Dun mina v'yokeh v'yasrem apikadon mushba mipiaz mochayav afedut mushba mipiaz mochayav v'yokeh v'atra מה מושפע מפי אחרים? בייס דין אין, שלא בייס דין לא. אף מושפע מפי עצמו בייס דין אין, שלא בייס דין, שלא בבייס דין לא. And the rabbis hold, infer the halacha from it, but interpret the halacha according to its own place. The halacha of the oath of testimony is derived from the halacha of the oath of a deposit, just as in the case of the oath on a deposit. One who takes the oath on his own is liable. So too, in the case of the oath of testimony, one who takes the oath on his own is liable, but interpret the halacha according to its own place and derive the details of the halacha from the halachot of the oath of testimony, just as in the case of one who was administered by oath by others. If he denies knowledge of the matter in court, yes, he is liable, and if his denial does not take place in court, no, he is not liable. So too, one who took the oath on his own, if he did so in court, yes, he's liable, and if he did not take the oath in court, no, he's not liable. Daf Yomi. Okay, now we're turning to page 31b, top of the page, with Amar Lahu Rav Papa. Rav Papa said to them, okay. Rav Papa said to them something very nice. Rav Papa said to the rabbis, if the rabbis derive liability for one who takes a false oath of testimony on his own by means of a verbal analogy from the oath of a deposit, then everyone agrees, infer from it, and derive the details from it, and even the rabbis would concede that all the halachot of the oath of testimony are derived from the oath on a deposit. Therefore, one is liable for an oath taken on one's own, even outside the court. Rather, this is the reason that the rabbis hold that there is no liability for the oath of testimony taken on one's own outside the court. They derive it by means of an a fortiori inference from the halachot of the oath of the testimony itself, as follows. And if one who was administered an oath by others is liable, when one takes the oath on his own, is he not all the more so liable? And ומה מושפע מפי אחרים? בייס דין אין, שלא בייס דין לא. אף מושפע מפי עצמו, מפני בייס דין אין, שלא בפני בייס דין לא. And from the fact that they derive the halakha by means of an a fortiori inference, one is bound by the limitations that restrict that derivation. It is sufficient for the conclusion that emerges from an a fortiori inference to be like its source. Therefore, just as one who has administered an oath by others, if the oath is administered in court, yes, he is liable. And if it is not administered in court, no, he is not liable. So too, one who took the oath on his own before a court, yes, he is liable. And if it is not before a court, no, he is not liable. אמרו לרבן רב פאפא, ממה זה סמרתלו בדון מיני, ומיני פליגי דאתנן, גם בפיקדון, שבועת הפיקדון, נוהגת באנשים ובנשים, ברחויקין ובקרויבין, קשרן ובסולין, בפני בזדין שלא בפני בזדין, ובעצמו פי החרם אינו חייב, עד שיכפור בו בדין דברי רבי מאיר. חכמים אומרים, בין בפי עצמו ובין בפי אחרים, כיוון שכפר בו חייב. The rabbis said to Rav Papa, how can you say that it is not with regard to the matter of infer from it and derive the details from it that they disagree? But didn't we learn in the Mishnah with regard to the oath of a deposit? The oath on a deposit is practiced with regard to men and with regard to women, with regard to non-relatives and with regard to relatives, with regard to those fit to testify and with regard to those unfit to testify. The oath on a deposit is practiced both in the presence of the court and not in the presence of the court. When the bailey takes the oath on his own, and if the oath is administered by others, he is not liable until he denies responsibility for the deposit in court. This is the statement of Rabbi Meir, and the rabbis say whether the bailey takes the oath on his own or whether the oath is administered by others, once he denied the claim concerning the deposit, he is liable. לרבנה דחיה דלאו דגמירלה מאדוס ושמה מינה בדון מינה ומינה פליגי. The question arises, from where do the rabbis derive that one who is administered an oath on a deposit by others is liable, given that an oath of that kind is not mentioned in the Torah in the context of an oath on a deposit? Is it not that they derive it from the halachot of the oath of testimony and conclude from it? That is with regard to the matter of infer from it and derive the details from it, and they disagree. The rabbis hold, infer the halacha from it, but interpret the halacha according to its own place. The fact that one is liable for an oath on a deposit that is administered by others is derived from the oath of testimony, but one does not derive that one is liable only if that oath is administered in the presence of a court. Rather, the oath on deposit administered by others is derived from an oath on a deposit taken on one's own. One is liable in both cases for an oath taken not in the presence of the court. Mehayin mehaleka lemishma mina. Rav Papa said to the rabbis, in that Mishnah, yes, it is evident the rabbis and Rameir disagree with regard to the matter of infer from it and derive the details from it. However, no inference is to be learned from this Mishnah taught with regard to the oath of testimony, as perhaps the rabbis derived their opinion by means of an a fortiori inference. לכולן נאמר בהן ונעלם, חלון נאמר בה ונעלם, The Mishnah teaches, and one is liable for the act of taking a false oath with intent. The Gemara asks, from where is this matter derived, that one is liable to bring a sliding scale offering for taking a false oath of testimony with intent? It is derived, as the sages taught, in all the other cases where one is liable to bring a sliding scale offering, see Leviticus 5:4, meaning the defiling of the temple or its sacrificial foods and violating an oath on an utterance, it is stated, and it is hidden. But here, with regard to the oath of testimony, it is not stated and it is hidden, which serves to render one liable for taking the oath intentionally, just as he is liable for taking the oath unwittingly. Amar Yehuda Amar Rav Ve'omer Yodea Ani Sheshvuos zu asuha Aval Eini Yodea Im Chayav Alea Korbanim Lo. Mishnah teaches, and one is liable for an unwitting act of taking a false oath, provided that he takes the oath with intent in terms of the testimony. The Gemara asks, what are the circumstances of the case of an unwitting act of taking a false oath with intent in terms of the testimony? Yehuda says that Rav says that this is in case of one who says, I know that taking this false oath, I do not know relevant information is prohibited, but I do not know. I know that taking the false oath, that I do not know the relevant information is prohibited, but I do not know whether or not one is liable to bring an offering for taking that oath. Sounds like moonbaz a little bit. It does so. Okay. Brace yourself and move. The Mishnah teaches that they are not liable for taking the oath if they are unwitting in terms of testimony alone. If one actually forgot that he knows about the matter, he is exempt from bringing an offering. The Gemara asks, shall we say that we learn in the Mishnah that which Rav said in response to the dispute of Gemara 26a cited a dispute between Kohan and Rav Asi with regard to certain statement of Rav. Each took an oath that his version was accurate. Rav told them that although the version of one of the Amoraim was not accurate, he is not liable for taking a false oath, as each Amora was convinced that his oath is true. This was not an unwitting oath, rather it is an oath taken unaware. It's kind of like the two students that swore that they were right and one of them was wrong. Okay. Oh, I think this is that case, yeah. Okay, law. No. Afal gav is time to sloka daitachmina, hahu to lok sivnelam, to inyan shagig dumya to mezit, aval hasam to sivnelam, afilu, shirasa, koldu, kamashpon. The Gemara responds, no. Even though we learned this halakha in the Mishnah, Rav's statement that the one who did not cite Rav's statement accurately is exempt was necessary, it may enter your mind to say it is only here, with regard to the oath of testimony, that one is exempt for unwittingly taking a false oath, as is, and is hidden, is not written concerning it, indicating that in order to be liable, we require that the halachic status of the unwitting oath is similar to that of an intentional oath, meaning he knows that he is taking a false oath, but he does not know that he is liable to bring an offering for doing so. Therefore, one who is unaware that it is a false oath is exempt. But there, in the case of Kahana Ravasi, where each took an oath on an utterance, where it is written and it is hidden, even if it is entirely unwitting, meaning they were totally unaware that the oath was false, one might say that he is liable. Therefore, Rav teaches us that even in the case of an oath, on utterance, one who is unwitting to that extent is exempt. Mishnah. The Mishnah says, okay, we're showing the Mishnah, and we're on the last stretch here, so it should be a nice flow here. Mishnah says, Shevuos educates on Amr Shnaim, Bo'u vehi'iduni, Shevuos she'ino anu yoidin lecha edus, o she'omru lo, ein anu yodin lecha edus, mashpia ani alechem ve'amru amen, harei elu chayavet. Liability to bring a sliding scale offering for taking a false oath, a testimony, how so? In the case where the plaintiff said to two individuals, come and testify on my behalf, and they replied, on our oath we do not know any testimony on your behalf. In other words, we do not have any knowledge of the matter you speak of. Or, in a case where they said to him, we do not know any testimony on your behalf. And he said to them, I administer an oath to you. And they said, Amen. If it was determined that they lied, these two witnesses are liable. והוידו בטורים כפרו חייבים על כל אחת ואחת השביע עליהן 5 פעמים בפני בית דין וכפרו אינן חייבים על אחת. אמר רבי שמעון מצאם הויל ואינם יכולים לחזור ולהוד. If he administered an oath to them 5 times outside court, and they came to court and admitted that they had knowledge of the incident in question and testified, they are exempt. But if they deny knowledge of the incident in court as well, they are liable for each and every one of the oaths administered to them outside the court. If he administered an oath to them 5 times before the court and they denied knowledge of the incident, they are liable for taking only one false oath. Rabbi Shimon said, what is the reason for this ruling? Since once they denied that they had any knowledge of the incident, they can no longer retract that denial and admit that they have knowledge of the matter. Therefore, there is only one oath of testimony, and there is no liability for the remaining oaths. If both witnesses denied knowledge of the incident together, both of them are liable if they denied knowledge of one after the other. The first to deny knowledge is liable. The second is exempt, as one of the first witnesses denies knowledge of the incident. The second is an individual witness whose testimony is not decisive. If one of the 2 witnesses denied knowledge of the incident, and the other one admitted that he had knowledge and proceeded to testify, the one who denies knowledge of the incident is liable. If there were 2 sets of witnesses that took the oath of testimony, the first set denied knowledge of the matter, and then the second set denied knowledge of the matter, both of the sets are liable because the testimony it can exist with neither of them. As even after the first set denies knowledge of the incident, the second remains capable of providing decisive testimony. Amar Shmuel. Okay, this is the Gemara. Okay, the Gemara says, Amar Shmuel, Ru Sheratz Achrehen. Ru Sheratz Achrehen. Amar Lo Ma Atar Ratz Achrenu. Shvua She'ein Anu Yodin Lecha Edus Beturim. Ad Shishmu Mipi. Mai Kamash Balantanina. Shilach Biat Avdoi Oishiyom Alehen Hanitba Mashbi'an Olechem She'ima Atem Yoidin La Edus Shetavo Sa'idu Harei Eilu Beturim. Shmuel says, if witnesses saw the plaintiff pursuing them and they said to him, for what reason are you pursuing us? On our oath we do not know any testimony on your behalf. They are exempt until they will hear a demand to testify directly from his mouth. The Gemara asks, what is Shmuel teaching us? We learn this in a Mishnah in 35a. If the plaintiff sent a 35 is Carla. If the plaintiff sent a request for testimony with his servant, or if the respondent said to the potential witnesses, I administer an oath to you that if you do not know any testimony on behalf of the plaintiff, meaning my opponent in litigation, you will come and testify on his behalf, and they took a false oath, they have no knowledge of the incident, they are exempt.